That's where the live. September 16th. Testing 1, 2, 3. Hello? Not getting feedback.
We got it.
All right.
Thank you, Mr.
Yeah, thanks for letting us know.
Jeez. Do you want to start back over?
No.
Okay, let's go. So,
Oh, regular. Okay.
Wednesday, September 10th.
Wednesday, September 10th at 6 p.m. And the reason why I picked that is Labor Day is September 1st. So I was looking for at least the week after. But that's my motion. Would anybody second that?
I second it.
Hey, motion by Bernard for September 10th, 2025 at 6 p.m. for our regular meeting, seconded by Close. All in favor?
Aye.
Aye. Opposed? All right. Motion carries. All right. We will close our regular meeting and move to our noticed public hearings. Yes, sir. Yep. Thank you, Mr. Close. For the public hearing, we have an appeal by Mark and Sherry Morris of the Planning Commission decision on August 12th, 2024, and signed permit on November 8th, 2024 for their short-term rental special land use permit 3025 Orchard Lane, Millington, Michigan. For this, we need to note that Mr. Opperman is prohibited from deliberating and voting on it because he made the decision on the Planning Commission, so Michigan Zoning Enabling Act, which leaves 3 in Mr. Close's conflict of interest. That does leave 3, which requires a unanimous decision for anything to pass, which is per Michigan law. So just so everybody knows that coming into it.
No, I could add comments. Correct.
I don't believe so.
Could I make comment?
No. Let me read the.
It's just that you're prohibited from voting.
Okay, I can.
So I don't know if we have procedures different. Ordinance under the Zoning Enabling Act is the conflict of interest on the vote.
Okay, a member of the Zoning Board of Appeals who's a member of the Zoning Commission, Planning Commission, or legislative body shall not participate in a public hearing on or vote on the same matter that the member voted on as a member of the Zoning Commission, Planning Commission, or legislative body. However, that the member may consider and vote on unrelated matters involving the same property. That's MCL 125-3601.
Participating on subject here.
Correct. It says shall not participate.
Yeah, please. Yes.
Okay. I just want to make sure we're not violating the state law.
We need to do that.
Okay.
So I might.
Though I would love to hear your opinions on it, but
I'm sure you would. I might step away. There's no reason to step. I can't.
Okay. And then you can return for the end of the regular meeting.
Sure.
Okay. Thank you, sir. All right. Presentation by petitioner or designee. Mrs. Morris. Mrs. Morris has also submitted documentation via email, which has been shared with the board. It's located in the public comment section of your binders. Go ahead.
Okay, hello. Okay, so why are we here tonight? To keep it brief, and I know that you all have documentation to support my position in front of you. I hope that you've been able to review it. I know it's a lot, believe me. I have a plastic bin at home, this big, full of documents. We have been fighting a 3+ year battle with the township. This is going on through 2025. And to clarify, not really with the township, but with a group of lake residents who do not want short-term rentals on the public state game Murphy Lake, which I have pointed out in many meetings is in direct contradiction to the township's master plan. And most people today use short-term rentals as a preferred way to travel. So we would not even have had that fight if the earlier officials had stuck to the master plan of limited residents and keeping it residential, which is what a public lake is for. In any case, this matter was voted on by the Planning Commission, board, who voted unanimously for, sent to Tuscola County Planning Commission for their review, who, by the way, advised it was fine, but said that the Dudleys and the Morrises should be grandfathered in. And this was also put in writing, and it's in your packets. There was an attorney who actually sat on that Planning Commission. The verbiage was haggled on back and forth as to what would be allowed, not allowed, guidelines, etc., voted on, approved diligently and carefully by all members. We then received permission to have our special use permit, finally in August of 2024. And that same group immediately appealed the Planning Commission and Board's decision. We came before this appeal committee on October 2nd, 2024, and you denied their appeal and simply added 2 changes to our guidelines permit, which were quiet time and parking. Since we never received the permit after that meeting, my husband Mark went into the township and Jackie, the clerk at the time, took the permit to Alvin on October 17th. He signed it, but when Mark got home, we noticed that these changes had been added to the permit that were not discussed, voted on, etc. And those changes had been brought up at a prior meeting in the form of guidelines for short-term rentals. They were on our chairs. We had never had a permit because we never received one. Since we were concerned at that time, as you can see by the minutes, and those are in your packets, we brought that up and we were assured that those changes were not in the final permit. The zoning administrator told them that we took the permit prior to it being ready. And that permit, October 17th, did not have the Zoning Board of Appeals 2 changes in it, but it had all of these other items. During this process, we have had to fight with the zoning administrator on so many issues. We were even told at one point that we had to shut down while the appeal they had going on was in progress. He actually told us that Alvin made that decision. So we asked him, and he knew nothing about it. She then denied saying it at the next meeting that we came to at the Planning Commission. So with these additions, and the zoning administrator, in our opinion, obvious bias against short-term rentals, obviously we are concerned. We do not want to have this verbiage in there, as words mean something, and we have seen her do this at meetings. It will simply be used to work against us. Annual review, as if we should have to go through this every single year. Very concerning. There should not have been any changes. We feel that she went over what her authority allows. And at the last Planning Commission meeting, 4 members questioned her about adding those changes. At first, she denied adding them at all. And then she finally admitted it and stated that she attended an MTA meeting where she learned this would be in the best interest of the township. The job description is not the ordinance. Nowhere in our ordinance does it give the zoning administrator power to do this, or the entire ordinance today. There's nothing in there. After 3 years of seeing how this process works, the care from the Planning Commission, the board, and the painstaking procedures they follow, including going to the lawyer in Tuscola County, it just does not make sense that she could just add these changes, especially the changes she added. In your paperwork, I included the pages from the actual ordinance that apply to the gravel pit. These items are in there. If they were meant to be in the short-term rental amendment, if they're there for the gravel pit, just makes common sense to me that they would be in there for the short-term rental amendment. She pulled them right out of there. We're asking you to remove all of these items that were not voted on by Planning Commission or Board. We tried to get this done at the Planning Commission meeting. They did not have a meeting in December. The only reason we filed the Zoning Board of Appeals was because we were advised to do that in case that decision did not go in our favor because of the new 30 days. There was no meeting in December. So January, we came and we pleaded with them to do it. But I think that they were trying to work with this zoning administrator who was telling them at that meeting that she had some kind of timeline for reasoning, but she wasn't prepared that night to come with that. So they all four were questioning her and they all let her have the time to do that timeline. So then we went to the next meeting and begged the board to do the same. We didn't feel this was an issue for the zoning board of appeals. It was something that shouldn't have been done. No one ever voted for it. The board too, same thing. They were advised by their attorney, we understand, that they were not allowed to make that decision and we needed to let this process play out. But they too asked Ms. Danzer, when and why did you add these items? She denied it totally, even though, and you guys have YouTube now. I'm really glad that you do. And I'm glad that people were brave enough to come tonight to say what they heard, some of the planning commission members and board members, because she sat right here and denied it again. And then when pushed, he admitted doing it, but now by this time, it's all foolish that they're in every permit, which, by the way, we talked to Alvin prior, he doesn't have annual reviews. And as far as we know, that's not in anyone else's permit. But even if it is, she shouldn't be allowed to add it. This is all on the video, as I said, and I have all that documentation. So if anybody has any questions for me, with anything you've seen.
Did you find the August 17th application in your packet? I couldn't find it.
Another important thing, November 11th, these are the minutes of the meeting for the planning commission. That permit was signed on November 8th. They even looked at it again. So this meeting says, Merck question. Okay, again, he's questioning. I remember him going up to the table. We annoy the crap out of these people, and I get it. And Alvin said to him, they're not mine. Like he was kind of like, get out of here. You're tired of you guys hounding us. It's just right here. He referenced the wrong permit.
Oh, I'm sorry.
They thought Mark was looking at the wrong permit. So they're not in ours. So we don't know. We don't get to see what you guys have. But Alvin made a statement that those items were not his, so we trusted that. So that's November 11th. That permit was signed by Alvin November 8th. So.
Any other questions? No. No questions?
I don't have any questions. I read through all the
Thank
material.
you for reading it. I know it's a lot. And Mark wanted to add a couple of things if he didn't mind. He's not as lengthy as me, so I appreciate it.
Okay, that'll be done during public comment.
Well, he was going to do it right now if you were fine, since we're on the presenting.
We'll do it
It's
during public
short.
comment. But thank you.
Okay, thank you.
All her names are on the agenda.
Moving on. Ed Maschke.
Yeah, I'm not here. We'll be the one that worked out. That's what we don't. Thank you, sir. Thank you.
And Ed, are you speaking on behalf of the planning commission or on behalf of yourself?
More on behalf of myself, with the knowledge I have as the planning commission co-chair.
Thank you.
Again, Ed Maschke, 7951 Houston Drive, and also, as I mentioned, planning commission co-chair. The concern that Morris has raised as a result of additional requirements being added to the special land use permit approval document. That's what this is really about. Okay. Their concerns focus on 5 items. Number 1, status of the permit. The permit shall be conditional upon the applicants meeting all necessary residential building, health department, and safety codes. This is section 14.26.B.1 of our approved standards. Per the August 12th, 2024 meeting minutes, which is shown below, highlighted in a different color of blue, The board reviewed the requirements, and as a board member, I recall all 10 standards being met and approved by the planning commission board, which includes that previous standard I talked about. Normally, when approving the Millington Special Land Use Permit approval document, the planning commission should have been documented by the planning commission. This item should have been removed. However, the key point here is the planning commission did not have the opportunity to review this document. Please note that. That's why it is highlighted in bold. Second, permit conditions. 4 items, L, M, O, and P, were listed on the Millington Special Land Use Permit approval documents. Issues with it. A, these items are not listed in the approved Millington ordinance requirements or the rentals amendment. B, these items were not reviewed, listed by the DC members as permit conditions during the August 12, 2024 special land use public hearing for this item. The only additional permit conditions that the planning commission voted on were items A, B, and C of this Millington Special Land Use Permit approval document. Again, when approving a Millington Special Land Use Permit approval document by the planning commission, items L, M, O, and P should have been removed. And again, however, planning commission did not have the opportunity to review these documents. The Millington Special Land Use Permit approval document was not approved at a planning commission meeting. The document was taken to Elman Zevik's for his signature. The planning commission chairman was not made aware of the additional requirements that were added to the document. Normally, additional permit requirements above and beyond the zoning ordinance are noted at the beginning of the permit conditions, as items A, B, and C were. However, L, M, O, and P are listed at the end of the ordinance item. N is actually a modified zoning ordinance requirement and is placed between these 4 items. First time that L, M, O, and P were reviewed by the planning commission was during the Millington Special Land Use Approval document of the Midwest Motor LLC, and that was on October 10th, 2024. The additions were not brought to the planning commission's attention. I noted the extra requirements while reviewing the document. Concerns were raised because these items were not mentioned, reviewed, or listed by the planning commission as permit conditions during the September 17th, 2024 special meeting for the Midwest Motor LLC. The planning board was informed that Midwest Motor LLC would accept the additional requirements because they were, excuse me, on an expedited timeline to open the business. Considering this information, that they would accept those extra requirements, the planning commission agreed to the document. That's a critical item. They accepted it. It is very clear that additional requirements were added to the Morris's Millington Special Land Use Permit approval document that were not approved by the planning commission. At this time, the appropriate actions from the zoning board would be to, 1, have the Millington Special Land Use Permit approved document amended to one, the status of the permit, amended to exclude the status of the permit. The permit shall be conditional upon the plaintiff's meeting all necessary residential building, health, environment, and safety codes. B, permit conditions items L, M, O, and P requirements. Those should be removed. Second option for this board to consider is send the existing Millington special land use permit approval document back to the planning commission to be updated with the items that have been approved by the planning commission. Considering the extra time, money, and efforts that the Morrisons have already incurred due to the errors made by the zoning administrator, I recommend the first action to help put closure to this item. Thank you for your time and consideration, Ed Maschke, Planning Commission co-chairman. Also, I would like to take this opportunity to voice my concerns with having Matt Opperman removed for tonight's voting. As noted in this document, the issue is based on the special land use permit approval document. That document that we're here for was never presented to the board, was never voted on with the board, was never talked about in a public hearing. So I feel the board is in error by removing him tonight. Thank you. Do you have any questions for me?
I don't.
Thank you.
Thank you.
All right, presentation by zoning administrator.
First, I would just like to point out that there is a very distinctive difference between an amendment and a special land use permit. I haven't done anything with the short-term rental amendment that was completely done by the planning commission, and I don't think that that's what's being appealed tonight. So I just want to make that distinction in terms. It is.
Could you repeat that again? I'm sorry.
There is a distinct difference between the amendment, the ordinance amendment relative to short-term rentals, and the special land use permits. Those are two very separate things. And so those terms are being interchanged in the testimony that you've heard thus far. And I want to make that distinction between those two things. It is inaccurate and defamatory for it to continue to be said that I have changed the permit without authorization and after the fact without giving the planning commission time to review the permit conditions. I completed a chronological account of the handling of the Morris short-term rental special land use permit and included it in an email for your review with all of the relevant exhibits throughout. It's a quite extensive review, and the exhibits, I think, total a total of 57 pages. So I will certainly not read all of that tonight. I do want to draw your attention to a few highlights. Included with the exhibits of the attached packet, relative to the special land use permit, at the very end, letter H, includes a narrative around the various terms and conditions that were incorporated into this document. Upon reading this document, you will find that the way in which the Morrises have communicated the application of these terms and conditions is grossly inaccurate. The terms and conditions of which they are complaining do nothing to hinder the operation of their business, and in fact, provide them with additional protections of the right to maintain their permit. You will also find that these terms and conditions and the special land use permit template that's included there provide additional protections to the township. These terms and conditions have been reviewed and affirmed several times by our legal counsel. In addition, as you will read in my account of my handling of the Morris short-term rental special land use permit, that these terms and conditions have in fact been reviewed and approved by the Planning Commission on at least 8 different occasions. If at any time any township official had any concerns over these terms and conditions or any other aspect of my handling of the short-term rental special land use permit, there is no record of those concerns expressed in any of the public records. I'm going to walk you through the important dates and actions that were taken. You have the timeline to follow along, and the exhibits that I will reference are in alphabetical order. On August 21st, 2024, I prepared a draft copy of the Morris short-term rental special land use permit. That's in your packet as Exhibit A. On September 9th, 2024, that draft copy, Exhibit A, of the Morris short-term rental special land use permit was presented to the Planning Commission for review. The meeting minutes show that the draft was reviewed and found to be accurate. Maschke moved to approve the wording as accurate and tabled the signing until the Zoning Board of Appeals decision, which was scheduled for the October 2nd, 2024 meeting. That motion was seconded by Opperman, and the motion was unanimously approved. Those meeting minutes are included in your packet as Exhibit B. On October 2nd, 2024, there was a public hearing held by the ZBOA to hear the Morris short-term rental special land use permit appeal. Those meeting minutes show that the ZBOA modified the Planning Commission's decision by granting the short-term rental special land use permit with additional conditions. On October 17th, 2024, the Morrises came to the township and inquired on the signed copy of their permit. The administrative assistant did take a draft copy, which was Exhibit A, of the Morris short-term rental special land use permit to the Planning Commission chair's place of business to obtain his signature, and the signed short-term rental special land use permit was delivered to the Morrises. Note that that document, which is in your packet as Exhibit D, contains the exact same language as Exhibit A, only now it is signed and dated. On November 11th, 2024, this is after it was realized that that copy was in fact inaccurate and needed to be changed. The Planning Commission meeting minutes will show a revised draft copy, which is Exhibit F in your packet, of the Morris short-term rental special land use permit, which was again presented to the Planning Commission and reviewed. Those meeting minutes will show that Maschke motioned, Opperman seconded, to approve the signing of the permit as it was presented. All approved, motion passed. The Planning Commission chair signed the revised draft copy, which is Exhibit F in your packet, of the Morris short-term rental special land use permit that night. Note that the permit signature is dated November 8th, 2024, but I assure you it was signed that evening on November 11th, 2024. On November 12th, 2024, I provided the Township Administrative Assistant with a copy of the signed short-term rental special land use permit to mail via certified mail to the Morrises. The permit signed on October 17th, 2024 was the draft copy Exhibit A of the Morris short-term rental special land use permit reviewed and approved by the Planning Commission on September 9th. Item J on this copy of the permit was in fact a clerical error. This copy of the permit did not include the modifications by the Zoning Board of Appeals. The Zoning Board of Appeals had modified the permit with additional conditions. They changed the parking condition and added quiet hours. This draft copy of the permit did not include those additional conditions. A new draft copy of the Morris short-term rental special land use permit was created, removing the incorrect item previously identified as item J and adding the ZBOA modifications, parking and quiet hours. That's the Exhibit F. Nothing else about those permits are different. The revised permit was included in my October 22nd, 2024 communication to all of the members of the Township Board, all of the members of the Planning Commission, and all of the members of the Zoning Board of Appeals, with a specific request for the ZBOA chair to review the draft permit, which is now Exhibit F, to ensure it accurately reflected the modifications made during the October 10th, 2024 ZBOA hearing. The ZBOA chair did confirm that it was correct. I used drafted, the permit for the Morris's short-term rental special land use permit using the Millington Township zoning ordinance, the amendment that was referenced earlier, the knowledge gained from the MSU Citizen Planner course I took, the various MTA workshops and conferences that I've attended, combined with my 10 plus years of professional experience doing legislative work, with the August 12, 2024 meeting minutes specific to the conditions imposed on Morris's permit, to draft that short-term rental Exhibit A. Since that original draft of the Morris's permit generated on August 21st, 2024, 3 things about that permit have changed. I removed the incorrect item previously identified as J and added the ZBOA modifications. Nothing else about those drafts have been altered since its creation on August 21st. The language in the Morris's short-term rental special land use permit has been reviewed multiple times. It was reviewed on September 9th. Meeting minutes, as I explained, show that the draft, and it specifically says, was reviewed and found to be accurate. You can read those meeting minutes. It was reviewed again on October 17th, when it was brought to the Planning Commission Chair for his review and signature. It was reviewed again on October 22nd. That's in that email communication that I sent to everyone asking for the affirmation that I had made the changes per the ZBOA modifications correctly. And it was reviewed again on November 11th, 2024, when the revised permit with the ZBOA modifications was presented to the Planning Commission for signature. 4 different times that permit and those conditions were reviewed by the Planning Commission. There is no basis for the allegations brought forth that I have changed any permit without authority and after the fact without giving the Planning Commission time to review the permit conditions. In addition, I would like to note that all of the other special land use permits issued since I was asked to draft special land use permits for the Planning Commission contain similar language. Those are all included for your review under Exhibit G. That includes the special land use permit issued to Tri-County Aggregate on September 9th, the special land use permit issued to Midwest Motors on October 14th, the corrected special land use permit issued to the Morrises, the special land use permit issued to Ackerman Clark on November 8th, and the special land use permit that is currently being considered for Paul and Renee Dudley. This means that the Planning Commission has had the opportunity to review the terms and conditions of the special land use permit that I am drafting for them at a minimum of 8 times. 8 times they've seen this language. So for anyone from the Planning Commission to stand here and say that they didn't have an opportunity to read those documents just simply says that the Planning Commission member didn't read those documents. There is absolutely no evidence to suggest that I changed anything about them. Those documents are completely at the Planning Commission's discretion. And if they wanted them to be drafted differently, they simply had to ask, or they could have just drafted it themselves. Any questions?
I don't have any questions.
I don't either. Thank you.
You're welcome.
All right. Public comment. Yes, sir. Come.
Paul Dudley, 3124 Husband Drive. So I'm one of the ones that my permits still in process. And then again, it's held up because of, it could just be signed and finished today, but it's held up because once again, these extra requirements that the zoning administrator added. I've been at every single meeting, and once again, it wasn't exactly how it was explained. The draft, there was 2 different drafts that were floating around out there. The one that they approved, it just had the the one that was approved on August 21st. But then this other one that had all those additional conditions that, that was decided on by the zone administrator. The planning board wasn't aware of that because we were always in the planning board states like, why are these here? Why are these here? And it ended up getting punted down the road like, well, they're not supposed to be there. We'll deal with it. So we went to the township supervisor as well. He wasn't aware that they were in there. So we confronted Robert. He said, no, these aren't supposed to be in there. We never agreed to those. So if for whatever reason there was two drafts floating around in there, and it could be, of course, that she emailed them out and communicated, but what they were voting on, they only voted on the original items. If they wanted the township specifically said they didn't want to do annual inspections. This extra fee that we needed to pay every year, why was it set at that amount? Why wouldn't it be $50? Why wouldn't it be $1,000? It was never discussed. It was just items that were just brought in that were not part of the ordinance. So that's the frustration is we as the public and anybody new that comes in that applies for this, they don't want to go through meetings after meetings. They should be able to, just like the gravel pit, come in, apply for your special land use permit, go away and never come back. But it's just all this confusion that happens down here at the office that's very frustrating. That why couldn't that permit on the night of August 21st be typed up, signed, and be ready? I know you have to delay it 30 days, but it could have been ready 30 days and go away. But there's draft after the draft, item after item put in and taken out. But once again, the planning commission didn't vote on it. We approached Matt, we approached Alvin. They didn't know about it. They didn't agree to it. Doyle, the same thing. He said in the last meeting, I never agreed to these things. But if they were put in through email or through notices or whatever, it just wasn't brought front and center to the planning commission where it was in their face, where it was communicated, look, these are extra things in there. Do you agree to them? Where they had that chance to really go through it because it was a surprise to all of them. So whatever, it's just a simple problem of not following process. And I know there was legal counsel that said, well, this or that, should happen. But once again, it's the planning commission that's the final decision. That's it. What the planning commission put on paper, decided on August 21st, that's it. And so none of them should be surprised when we bring in these permits of ours that say all these extra things. They should be able to back it up and say, oh yeah, that's right. You're right about it. But it's just been nothing but confusion. And once again, I think for the most part, Ms. Danzer is trying really hard to do a good job. She was very, very helpful with me in getting my application started. The big complaint is just not following process. That's all we're after is just please follow the process and make it simple for us in the public. Thank you.
Paul, may I ask you a question? You mentioned August 21st. So I look at your pending permit as October 14th. What is October 21st you're referring to? Is that when the ordinance went into play?
No, it's just I went to see when the Morris's got theirs approved. So all of us that applied, we knew what was going to be required of us because ours would be the same as the Morris's, except if there was some condition that the planning commission would come up with. For example, they did ask me to put up a fence or put up a bush, but everything else would be identical, and it'd be same with the Clarks. Theirs would be identical to mine, is identical to the Morris's, so that there's, it's all equivalent, unless there's something about the house that requires, a minor change,
Okay, thank you. Great.
My name is Alvin Zavis, I'm the chairman of the planning commission, and this tender is correct. It was brought to us 8 different times. Every time it was questioned. Those items are not part of our ordinance. They've never been amended to our ordinance. We were told that she took MTA training. This is what the state recommended. Township gave her the blessing to add these to make them standard in every short-term rental. We go to the supervisor of the township, says it's never been brought to the township board. That is not a true statement. One of the township board members supported her when she made that statement. The feedback from all of us was, bring us this information so we can look through it, see what's suited for our township, because we were told by the county board, do not do inspections. do not require them to have liability insurance. We were told by our township board they did not want some of these things. So they, from the beginning, when they were brought to light, in all 8 of them that we did see and we did read, so yes, we were aware of them. They were questioned every time. The last meeting, I said, once again, bring us the MTA information. If this is going to be part of these, it needs to be adopted and amended to our ordinances. It's never been, the information is yet to be brought to us. She's supposed to bring it to us. We've never approved, we've never voted on or discussed putting in this in any of them. They were added after the fact. Yes, we did approve the short-term special use permits after it was added, and we should not have. We should have rejected every one of them and said it's not verbiage that we put in there. We did not put any of this in there as a planning commission. We did not vote on it. Did we vote on the approval afterwards? We did, with the understanding that this was what the township board directed the administrator to do because of her training. Then we find out, once this all becomes a light and becomes a serious issue, she was not directed by the township board. She was not told by them to add this stuff. She did it on her own. Then that's when all the issue really become a light. So this doesn't belong in that. It needs to come back to us. We need to fix this problem. And if we're going to use any of this in our short terms, in our special use permits, it needs to go through the procedure, which we've gotten in trouble for, and we need to amend it once again. And it needs to go through the process. We as a planning commission did not put that in there. We did not vote on it. Yes, we did sign off on it. Because most of them, the Clarks and the Morrises, wanted their permits because they were scared they were going to get shafted and lose their short-term rentals. They were scared something was going to happen and they were going to lose their rentals. The Dudleys are the ones that were patient and said they didn't have a problem waiting. Sort this out and figure it out and then sign it. So her statement of, did we see 8 copies of this? Absolutely did. Absolutely see them. Did we approve some of them? Absolutely did. But every time it's been questioned and the question's been asked, why is stuff being put in there that we did not put on? Why do these special use permits have stuff that the planning commission did not discuss in open here in a hearing? Why is it on there that we didn't put on? So we did not approve those.
Thank you, sir.
They're not a part of our ordinance currently now either.
Thank you.
Hi, gentlemen. I actually sent these into Jackie right before 4 o'clock, but I don't know if they were received, so I printed extra just in case.
Appreciate it.
Well, this is part of the packet that won't be presenting a part of our appeal, but because the vote is so pressed upon these extra items, I do have a couple attachments that I wanted to include. So as far as what you'll see below, if you want to go to attachment 7 within the documents that you've been provided, you will see a timestamp email from the zoning administrator, which shows the original provisions and requirements that were to be met with our short-term rental application, as well as the document, which is called the procedure for processing special use permits, is also referenced. You'll also see on the original attachment 8, the ones that were in the email that were sent to us on 9/13. And then you'll see the ones that were added after the fact on attachment 4, page 3, which is our actual special use permit. I actually went in there and marked off what was added onto the documents. From the same processing special use permits document, which is again section 9 or attachment 9, sorry, it says that once a plan is approved by the planning commission, it shall not be altered without the consent of said planning commission. So my only question there is, were these extra items approved before being added? As far as Alvin, what he had to say, it sounds like it was not. As far as the liability insurance section that was added to our special use permit, the verbiage is eerily similar to section 5.03, which is the quarrying of soil, sand, clay, gravel, or similar materials, which is attachment 10. There is a paragraph taken directly from that verbiage and put into our special use permit. If you read into it further, it talks about machinery and or equipment being left on site. That doesn't pertain to anything special use permit wise. And then I also brought this up at the township meeting because trustee Alan Green was on the board. I don't know if he still is. I think he's not anymore.
Wait a minute.
Yeah, the township meeting. Alan
Are
Green
you
was on it.
speaking to your The appeal against your own property or the Morris property?
More property. But this is
Okay,
all
sorry.
pertaining to the same thing.
okay.
Okay,
Well, I was
No,
gonna say something
all,
about
all
him.
pertaining to the same thing.
got
Same
it.
argument.
And we'll give you the 20-second grace period
Yeah,
there.
but
Sorry.
as far as the liability insurance, I brought that up to Alan Green in the meeting because he is an insurance agent by law. And by the township requiring a certain liability insurance, if something were to happen to a tenant, and let's say the insurance lapsed, or let's say that the policy renewed and they changed the policy or whatever, something happens, and then all of a sudden you guys have that requirement in your bylaws, you're going to find yourself liable and end up in a bad situation if something bad happens. That's not something that you should be necessarily requiring. That's just my tidbit, but that was everything. Since we're talking about exactly that, I want
Thank
to give
you.
you guys
When the speed talking
yeah.
award on that.
Exactly.
Next. Hmm. Sir.
I don't know if you still got my job description of the zoning administrator. You should have. I had it in the packet.
Yes, we do. Here, hang on 1 second. Somebody can. You can share. Let's see here. You get this clip on it. All right, go ahead.
Okay, I want to point out there was a serious procedure that was missed for the zoning administrator, and that is number 6. It says properly bring any perceived deficiencies in the zoning operation to the attention of the supervisor. I had no idea stuff was added to the short-term rental until it was presented to me by the Morrises. So she did not fulfill her duties. And you asked her why? Because she knew I was very vocal when we went through all these procedures with Ed and Luann that we do not want these in the amendment. That's why they're not in the amendment. Because we were very vocal about it. We do not want these in there. So she did not do her job. She did not come to me. I didn't know anything about it until the Morrises approached me because they was at the meeting and said, I thought these were going to be left out. And I said they were supposed to be, which they were in the amendment. So I think the best way to remedy this is to kick it back to the planning commission and let them do their job. Thank you. Any questions?
Thank you.
James Doyle Fletcher, 9800 State Road. I'm also a member of the planning commission. And the items that the other members have talked about, we didn't discuss, we didn't vote on, we didn't approve. And I have been spent the last 2 weeks investigating. I notified the supervisor this morning that I was bringing charges. She has changed our ordinances. She has added things in that were not ever talked about or discussed. I have a copy of the last special use permit that was given to the gravel pit. And when we approved it, we approved it as is. Did not add anything. Well, there's 7 items that have been added to that permit. And if you would like to see it, it's laying on the dashboard of my truck. So be very, very careful when you're thinking about all this and deliberating it. And I think the best solution is this all gets sent back to the planning commission to straighten out. Thank you.
Thank you.
I'm 8426 Oak Road North of Nash. I'm part of the planning commission. So planning commission established ordinances with the assistance of the Millington Township Board and legal. The planning commission approved the ordinances. The township board approved them also, and we sent them on to the Tuscola County Planning Commission Board. They approved them. They wrote a letter, said we did a really nice job to them. Mark and Sherry Morris's short-term application was voted on and approved on 8/12. On 11/8, the special land use permit was sent out to the chair member, Elvin Zabit's business, asking to be signed because the Morrises wanted the short-term rental permit. Unknown to him, alterations were made to the short-term rental. The letters L, M, O, and P language was added to the permit. No one at this time discussed the changes that occurred. Changes occurred sometime in between 8/12 and 11/8. So this permit of the Morris really is fraudulent. It got changed.
Yep.
You asked her.
Please continue, sir. No. Please continue.
If changes were to occur, the planning commission would need to amend these changes. After this time, then the changes would occur in the ordinances after they were amended to the ordinances. During the short-term rental meeting on 10/10, we noticed with the Midwest that some of these changes were in there. Changes were made to the Morris's STR, including, again, L, M, O, and P. A couple of these items were considered by the planning commission. We refused to include these in the changes of the ordinances that we were establishing, and we left them out of the draft to be approved. The zoning administrator on 113 admitted that she did make some changes, and she did make changes because of some training at MTA. She was working outside the responsibility by adding additional items. The Morris's appeal is justified. Changes were made. It's up to the zoning board to uphold this appeal, remove the L, M, and O, and P, pass this back to the planning commission to clean it up. These changes should be considered insubordination. The township supervisor should address these actions of the zoning administrator. Thank you. Do you have any questions?
I don't.
Thank you. We've had the entire planning commission now.
Well, I figure you've heard from the rest, you might as well hear from me. Luann Jarzel, 10181 Sheridan Road, Millington. Tammy is right that she sent those to us on multiple occasions. I, for one, read my emails. I have had other planning commission members claim at the meetings they did not have time to read it before the meeting. Well, then we should have taken more time at the meeting for them to read it properly, to know what they're approving. I read every one of them. None of them got back with her for questions. She always includes at the bottom of her emails to us any questions or if you need clarification, please contact me. They're all missing the point that the ordinance says this. This is our base to start from on a permit. And then each permit will be tailored, as it were, to what it is. A dog kennel is not going to have the same thing as a short-term rental or a beauty shop. So that is where the extra conditions come in a permit. They've got to be thought of separately, and it has been confused in many of the comments up here. One of the things that gets mixed up is annual review. That is not for a person withholding the permit to come in. That is for the planning commission to review the permits that we have out there. And then if there has been a problem with one, then the planning commission can address it. That has not been done in probably 20 years, and that's why we've had several problems with certain issues in our township. We need to make the changes to stay current and to protect the township. I, for one, am all for protecting the township and following legal advice. And Tammy always sends us the lawyer's comments when she's contacted them, her questions. She asks if we have questions so she can take it to our township lawyer. And if they don't send in any questions, they've got no right to complain today and say, oh, I didn't know. We did review it. It was approved, and they need to stop mixing up ordinance and permits. This is not a day for Tammy bashing. This is a time to go over this particular issue on this particular permit.
Thank you.
Give you 3 minutes of the public comment.
Yes, sir.
And Mashpee 7951 Houston Drive. I think you all received this package from the zoning administrator, over 60 pages of documentation. Again, it's hard to go through every piece of document, every word. When she brings documents to us and we question, when we start listing what's actually in our ordinance, we say, are the verbiage from the section down our ordinances? And we figure they are. As I noted earlier, the only changes from our ordinances that the board approved for the Morrises is A, B, and C. The other stuff was hidden in all the extra paperwork. Again, the board was concerned about these 4 items being added. For the other items, the other special land use permits that were then reviewed after that date to identify them. However, the board was put under the impression that if we did not add them, the township board would not approve the ordinance, the special land use permit. So again, we were under the total impression that they were approved, wanted by the other board. But you heard from Robert Loomis tonight, that is not the case. I do, again, support what the other boards asked for too. If you're not going to amend what has been changed, the existing by option A or option 1, please go option 2. Have this moved back to the planning commission to do our due diligence. Thank you.
I know Mark wants to speak, so come on forward.
And we're gonna have another public comment too, right?
For the other
Other,
permit, yes.
Okay, listen, something so simple, I can't see why you can't, why people aren't seeing this. So, let me explain it simply. The night that they voted on it, I noticed on my copy out in the audience that those 4 items had been added. So I approached Alvin before the vote. Because what are these 4 items here? These are not on the original documents. He showed me his document as he's sitting at that table like you are now. Turn it around, show me. Mark, those 4 things are not on here that we're voting on. Okay, so no problem. So what I'm getting at here, the document they voted on that night was the one without the 4 items on. That's the legit document. The document that was brought to Alvin to sign was not a legit document. Whether it was signed or not, at that time, it was a clerical error. Well, I can't simply be corrected as a clerical error by taking him the right one to sign. So what I'm getting at is, those 4 things were on there when he explained that to me at the table, and that's what he believed that day he was signing. Just as the president sits at his table and signs all those bills, you don't reread them. You trust the personnel that are under him who have it correctly written already. So what we were given as a document for that, it's not the same document that we voted on, so it should not have any legitimacy whatsoever. And this is a problem that's been ongoing. I've spent over 70 nights here in the last 3.5 years. 70 nights of my life going on over this. And these people just keep coming and coming and coming at us. And so there's simple things that this all adds up to what we're hearing here. I'm not the only one she's going after. There's several people issuing a warning to stop loud music and stuff like that. We have no music law or no law against so we don't have a noise ordinance in here. I'm sorry. We don't have a noise ordinance. She had no business stuff. Well, write him a letter and scare the crap out. Then write him a letter about flagpoles, calling them structures, and we had to remove them, which when we remove the flagpoles, they're down in 5 minutes. So she has no jurisdiction over somebody's flagpoles in the yard. So according to her, now that I have a flagpole in my yard, it's been there for 20 years, I'm going to need a permit for it. She's going to keep going on and on over this stuff. The signs, everything. She don't enforce the sign ordinance. The 10-foot rule from the side of the road. She just, it's out. No, don't have to do it. And let's see. I'm gonna read what I notes.
And permits issued before ours, there was no changes on permits. The permits, those changes came afterwards on the other permits. And what those people, they're not here for over 70 nights for the last 3.5 years. They don't know what's going on. They just think that's normal, so they sign it. So I don't see how that holds any water in the timeline. That doesn't hold any water.
Thank you.
Thanks for your time.
Quick, public comments?
We allowed somebody else on the agenda to do it, so yep.
I just have to counteract a little bit again of what Tammy said. So a permit issuance, a zoning permit shall be issued by the zoning administrator whenever the proposed use complies with the provisions of the ordinance. It's all about the ordinance. She doesn't write the ordinance. She doesn't vote on the ordinance. She has no business writing or adding anything that's not voted on, just like these guys said. And I appreciate that they came and did that tonight because this has been a mess for us. We're like, how do you prove something that we knew was true? Here's minutes from the August meeting. Reviewed requirements of ordinance amendment, section 14.26, 1 through 10. 1 through 10. Right here in the minutes. That's what is supposed to be in our ordinance. Right here again, the gravel permit. I cannot stress enough, this is actually in the ordinance. If that is so important that those things should be in that short-term rental amendment, then they would be in here just like the gravel pit. And she did make one change. Under insurance, she put annually. It's just little things we feel is to poke at us. So if we don't do that, then we're going to slap you down. But she has a habit of going after certain people violations and other people finding some that don't even fit. So thanks.
Thank you. All right. Does that conclude public comment?
Nope. So there's all sorts of misconstrued information being shared tonight, but I would absolutely encourage you to take a look at Exhibit H, which is the actual permit conditions that are being questioned tonight. Like the Planning Commission shall review this permit annually, and the Planning Commission may revoke this permit if any non-compliance exists. I mean, that's reality. Like that's what happens. If the property owner or operator violates this agreement and or zoning ordinance, the Planning Commission may, following notice and a public hearing, revoke the special use permit. Again, like information. Like read through them. Like there's nothing in here that is malicious or that takes away from their permit. Aside from that, if there is this mysterious original permit that I changed, then I would ask someone to please produce it. Let's see a copy of what I brought if it wasn't the copy that I gave you as Exhibit A. That's the only thing I've ever drafted for them. If there's something else, ask them for a copy of it. I'd like to see it too. And if, as I said earlier, there was anything that they wanted changed about the permits before they signed them, they should have asked for that or changed it and drafted it themselves. Nowhere in the minutes does it reflect that they asked for any changes relative to these permits.
I got a question for you, Tammy.
I would love to answer your question.
It seems like a big part of this problem is the drafting of the document. Do you think that should be something the Planning
I
Commission?
think they absolutely should draft their own documents because there wouldn't be any sneaking anything into their documents because they didn't read them. Well, no one has to do that.
All right. Thank you.
I didn't ask that to try to stir anything up. It just seems like that would be
Another public.
When we produced the original document that they had and what was signed, and
We have it.
yeah, we have it.
We have every version. No other versions have been submitted.
Thank you for asking.
My name's Rachel Opperman, and I can just speak on behalf of the short-term rental application that we got, the permit. And this was an email. You guys have Cody gave you a copy. Attachment 8. So we were kind of surprised going into the October meeting as well, just because the additional line items were added. We tried to be really thorough with prepping for the meeting, and so it was a surprise the things that were added. And so our attachment doesn't include the additional items. So here's what I have to say.
Thank you. All right. Now, does that conclude public comment?
She said attachment 8 doesn't include the
No, it
original.
doesn't have the actual item.
That's
I'll
what we
capture
use
that.
to prep for
You
that.
can look at the permit, which is attachment 4.
Okay, thank you. Thank you. Thank you.
Yeah, thank you.
All right, that will close public comment. There were no letters submitted for the record.
I called up to see if there was, and there wasn't.
I called Jackie at home too and to confirm.
Here we go.
Um,
Okay. I'm on that comment. ZBA to, oh, I'll let you read that.
sorry, you catch up on your notes here?
Vice Chair, yeah, go ahead.
I'll wait for you.
Yeah, you're good.
You ready? Okay. All right, discussion and action.
Wow,
Um,
what a mess. It seems like we should reverse it, right? And send it back to the planning commission.
well, our decision authority here is an administrative action. So our action is limited to determine if a decision was properly made. This is from our training that we all took through the MTA.
And these are special notes?
These are my notes that I took from the training.
Okay.
Yeah. So yes, my only copy. Was the ordinance used incorrectly or with wrong information? Would be a question. Did they act incorrectly? If yes to those, an incorrect determination may have been made. If they made a proper decision, not if we agree with it, the decision was made, the appeal is denied. If a mistake was made, then we may overturn that decision and state why. So that would be our administrative options made to us based on at least my notes from the MTA training number 12. So the request from the Morrises is to have the permit modified. So we've heard quite a bit from planning commission members. Their minutes state otherwise. There's an issue there, and I can't ignore it. I went through and looked at their documents. And they're provided to us here as well, but November 11th, the meeting minutes indicate that they reviewed the permit and they unanimously approved it, and the chair signed it as he concurred. He signed it. Though they're saying that they didn't review it, their minutes state that. Additionally, on January 13th of this year, they reviewed those minutes and they accepted those minutes with no changes about the permit. There was a times listed as one change. Those minutes have not been approved yet, but those are the minutes submitted by the secretary per the Open Meetings Act. They've signed every document. They're all the same. We know that there was the change regarding how the inspections are done, but they did it over and over. They're claiming they didn't read it. They approved it and they signed it.
You want to make a motion? I mean, it seems like there's a big, I mean, Tammy says she didn't add it. Planning commission says she did add it. Almost every planning commission member wants it reversed so that they can fix it.
Contrary to the minutes.
Well, I'm saying what they're saying now.
There's a process.
They don't have a quorum. They don't have a meeting. They did not speak as planning commission. They spoke as individuals. They don't have the authority to do that, just like we can when we go and speak. The only way that I can speak, and which I do that, is we always have it in the minutes of what I'm going to go talk to the township board about. I always get your guys' approval.
Absolutely.
I make sure it's documented. Yeah. That was not documented, and I confirmed that with Ed. And Max. So as a group, Under the Open Meetings Act, they did not ask for this. So the challenge here is, I don't think we're in any position to modify the items as requested by the Morrises. So then I look at this very simple. We either reject the appeal and it stands as is, or we reverse the decision of the Planning Commission, which means there is no permit. It starts back from square one, which is what we've heard a number of people ask for. But that's unfair too.
That's very unfair to the Morrises as far as time and money and
Yeah, it feels very unjust to them, even though, I mean, truly, that's what we heard a number of people ask for. But they're not the ones that filed the petition, and they're not the ones making the decision. Then I go and I look at this permit itself, and I read the conditions. And one of the conditions they're arguing is the one that gives them the option of fixing this. It states right here, and this follows our ordinance. The commission may, upon the request of the applicant or its own initiative, modify the requirements of this permit upon such findings of need and justification, and upon a formal special use permit amendment being made under the same procedures using for adopting the initial permit. Therefore, they can go and ask, or the Planning Commission can ask, using, of all things, the disputed language in this, to make that modification. They have to go through a special hearing. They have to follow all the rules instead of circumventing them. Like, quite potentially, they might be trying your thing. But they have, this permit gives them exactly what they're asking for. So that's where I have a real challenge with what's being asked for, is the mechanism is right there. So we either uphold the permit as it is and deny the appeal, or, my gosh, we reverse the decision of the Planning Commission, in which eliminates their permit. They have to start from square one. They lose the permit. Planning Commission, I would think, would grant it again, but they lose it instead of modifying it.
Seems like the best option.
What's that?
Reverse it to the Planning Commission. Start over. I mean, completely reverse it being approved, because nobody's happy with it. So that gives them the opportunity to start from scratch.
So they lose the permit.
If we're not going to affirm it with conditions that we remove L, M, O, and P, which is like George said, the only way to do true justice to the Morrises would be to affirm it and add these conditions and remove those line items. That's what the contention's about. That's what would make them happy. They wouldn't have to go through the process again. It would be done. I'm willing to do that. I think that makes the most sense. That saves the township the most amount of money, less amount of more work on everybody. The Morrises, I believe, would be happy. Right? I mean,
but we just circumvented the process.
We don't want the Morrises to have to start all over with their stuff. But in the same aspect too.
Nope.
Sorry. Them things have been floating around and they were signed and looked at different times.
They keep getting it. We see it over and over on other permits as well. Our next special hearing is about another permit with the same issues, though that's not what's being appealed on that permit. At least not that I know of.
not yet.
Well, we're beyond the 30 days now, I believe. But
I don't think Tammy did anything maliciously or anything like that. Or
Can you speak up?
I don't. He said I don't think Tammy did anything maliciously. I don't think this is about Tammy or the Planning Commission at all. I think it's about it doesn't matter who messed up. Somebody messed up because the Morrises are under the impression that their original application is different now, and they don't know how it was changed. So no matter what happened or what the timeline was or who's responsible, it doesn't matter. All that matters is they're appealing their own permit because they want it changed. So we have the ability as a ZBA to affirm the planning commission's decision on the original application and remove line items L, M, O, and P, and this is done. Or we reverse it, like we just said, that we completely deny it, and they go back from square one. They might not even pursue another application or another short-term rental. Well, we thought the same thing with the mudbog people, right? I mean,
Well,
Separate issue though.
right.
Yeah.
Just for example, I mean, do you want to make a motion?
I see two options here. We either deny the permit is under item P, they have the mechanism to go get it modified. I can't support modifying it. I can't because they keep affirming it over and over and over. If the planning commission has to read their documents, it's been put in front of them. We have their signature multiple times. They keep saying, well, we signed it. Yes, they did. Well, if they don't take a break before signing something, I mean, are we looking at nonfeasance or malfeasance at that point? It's mind blowing to me that they wouldn't have read it before signing it. So I am so concerned about modifying it. So
make a motion and we'll vote on it. And
do we ask a question to the Morrises or do we just make a motion?
Yeah, no, ask the Morrises.
Mark
and Sherry.
Mark and Sherry, we have a couple questions for you.
Sure.
If you were presented with the option of you keep your permit and you can go through the process identified under P to modify it, or your permit, the decision is reversed, thus you start from zero.
Can you explain to them a little more in depth how that would work for P? Not getting it just a little bit.
Okay, it's okay.
You want to talk to me for a second?
Oh, I'm
sorry.
Sure, absolutely. Understandable. I know it's unconventional to ask you, but
Maybe you could remind them, I mean, that we do have to make a unanimous decision.
yes, and we must make the unanimous decision. I mean, it's based on the bylaws and state law.
At this time, I'd like to withdraw my appeal.
Is that an option, sir? Mr. Love?
Okay.
And then
Well, that's important.
back to the board and
They will have to withdraw it.
Okay.
I think you've made.
that's
Thank you, sir.
I didn't know that before, but not before, but I thought everybody was gonna go the same way. And I understand your reason, I think. Thank you, guys.
Thank you for your understanding.
Okay, so
Okay.
it's done.
Chair,
Yes,
probably
sir.
just make a motion accepting the withdrawal of their appeal.
Thank you, sir. Motion to accept the withdrawal of the appeal from Mark and Sherry Morris.
I'll second that.
Okay, all in favor?
Aye.
Roll call. Laura?
Yeah.
Yes. Zansky and Bernard. All right, motion carries, and we are closing the public hearing regarding the Morris appeal.
That's made to accept the withdrawal.
Do we, we've got another special meeting. Do we want to take a break or are we ready to jump into it? How about we take roughly a 10-minute break, so we'll motion to recess?
Second.
All right.
Yay, break.
Roughly 10 minutes. No,
Oh, you're fine. At what time?
7:43.
7:43. Do we want to mess with this or just leave it going? We'll just leave it going. I don't want to
Okay, we will reconvene.
I don't think I messed it up, so.
I don't think you did. Okay, we've returned from our recess at 7:51. Motion to move to the special public hearing, which is the appeal by Smith Boval, attorney for Steve Lay, Emery Close et al., of the Planning Commission decision on October 14th, 2024, and signed permit on November 8th, 2024, for the short-term rental special land use permit of Opperman Clark, 47655 Osborne Drive, Millington, Michigan. We will have a section in a second for the petitioner, though I do want to bring something to the attention of the Zoning Board of Appeals here. On page 35, so you're right before the last one in this batch, I'm going towards the end there. Before this final tab, there's page 35. 35. There we are. We received this appeal, and it included an appeal for the Opperman Clark permit as well as the Morris permit. I consulted for legal advice and had asked about that. And it already had been appealed by this specific group. So therefore, as chair, I sent the letter listed on page 35. That was under the guidance. If you go beyond your last tab, there is attorney-client privilege communication. And that identifies why that letter was sent after the tab. Very last page. And that identifies why I made that move. However, with that being said, I would like for this board to concur with that decision before we take any steps forward.
Because you made it on because you made it on your own.
I made it on
Right.
my own because of the requirement of me to create the agenda and to move forward. So I took that liberty as chairman. And for us to meet about it, it would have required public notice and everything else. So, but I took that and based that on this attorney-client guidance.
Okay, I'll make a motion to approve the letter that Robert Bernard sent on our behalf.
Second?
Second.
Yes. Any discussion? All in favor?
Aye.
Aye. Okay. All right. We have that component handled now. All right, Mr. Concanon, are you the one to speak? Come on forward, it's your turn.
Mr. Chairman, thank you. Good evening to you and to the other members of the board. I've been here, I think, the mud bog and with this project, maybe my fourth or fifth time. I will really endeavor to be brief. Page 54 of the zoning ordinance of Millington Township says with respect to special uses and the standards are 1803G. All specific requirements of the zoning districts where the proposed use should be located shall be compliant. The area, I think everybody at Murphy Lake is on a private road, or at least with respect to the permanent issue here. This one is. Your ordinance, it's ordinance 10-2 provides that there has to be setback and road frontage requirements with respect to any parcel where this special land use would operate. I would call your attention, Mr. Chairman, there's a series of amendments to the zoning ordinance that were done back in the spring. Not one of them amended section 10-2. All right. So when I read you that very first provision of section 1803 paren D, again, page 54,
that zoning, the zoning ordinance with respect to private roads has to be complied with, whether or not you agree with or disagree with the arguments I previously made relative to the master plan or the consistent uses with other areas of the property. I'm sorry, other properties within the area rather, or whether it's business use in a resort area. The fact of the matter is that there is a private road ordinance that impacts this. I think Ms. Denzer had even gone on record as referencing that. For what it's worth, somebody said this is not a referendum on Ms. Denzer, but having been here a few times, including the debacle with the mud bog, I think she deserves a little bit of thank you for what she's done. It's been a difficult job, and I'm grateful that the board is shaking its head.
Yes.
For all we've heard here tonight, she's trying to do her best for the township and its constituents and the applicants. So I think that's just worth mentioning. Having said all of that, when you look at the circumstances here, there is no sufficient frontage on the road, which I think you have to have 120 feet. They don't have that. And by the way, when I went back through preparing for tonight, I looked through the FOIA response, which I had received from, I believe, the clerk, which did not include any site plan material, which would tell us that the Opperman/Clark parcel is compliant with the private road ordinance. So unless and until that really comes up here, I think mercifully, this can be a much quicker hearing than the other one. Either I'm right and they will come up here and say, yeah, we didn't provide it or we don't have that setback, and their permit is, the decision of the planning commission is overturned, or they come in and say, yeah, our setback and frontage is this and this, and here it is. And then all of a sudden you say, well, the planning commission permit was sufficient. Your charge, as you well know, is to base your rulings on competent procedure and whatnot. And I'm not complaining as we sit here on the procedure, but it's got to be in conformity with the law. Again, I read you your law when I read you about the 1803D and the zoning ordinance set forth for 10-2, which I attached to the appeal and which is in your packet. I'm sure that Tammy had provided to you. Section 1C, no zoning compliance permit shall be issued unless the parcel or lot fronts on an existing private road or a private road approved to the standards of this ordinance or on a public road. Each lot or parcel shall have road frontage equal to the minimum lot width required by the applicable divisions of the zoning ordinance. There's no evidence in the permit application that I saw that was met. There's no evidence in the permit, as I understand it, that was approved that was met. So how are you in a position to say that the planning commission was made in accordance with the ordinance of the township of Millington? I don't think that you can. So I'm not inviting this, Mr. Chairman, but the fact of the matter is that either A, I think the board overturns the permit utterly for lack of proof of compliance, or B, it remands the matter back to the planning commission for consideration of the permit anew as to whether or not compliance with any private road setbacks has been met. And if it hasn't, then the planning commission will presumably deny it properly, or they should deny it. And so that's really, if I have an ask, it's one of those two. But I think, quite frankly, if they had the right frontage, it would have been presented to the planning commission. It would have been presented in, I have not seen the packet that Mr. Clark produced for you. And I'm not asking you to give me a copy, but what I would ask you is, do you see anything there that tells you that they've met the setback requirements of 10-2? I suspect the answer is no. If I'm correct and the answer is no, I think you have only one choice, and that is to reverse granting of the permit by the planning commission. Unless the panel has any questions for me, I don't have anything else for you. Chairman, anything?
Are there any questions?
Did you understand where he wanted you to look?
Oh yeah, I get it. I mean, I don't have any questions, no.
No.
Thank you, Mr. Chairman.
Okay, thank you.
Appreciate it.
All right. Presentation by zoning administrator.
I don't have anything to add.
Thank you. Public comment. Timer.
We have 3 minutes.
Yes.
Okay. My name's Rachel again. As far as the ordinance being referenced, I'm gonna let my husband talk on that because he has looked at this in great detail. I believe they're referencing a commercial ordinance, so I'll just let him talk on that. I guess wanted to make the point, number one, coming here for this, appeal, we weren't given any grounds on what was being appealed, so that was kind of frustrating because we're kind of grasping at straws on where they're gonna try to poke holes in the story or in our argument, I guess you would say. I don't mind seeing your guys' faces and coming here, but it's just been this long, drawn out process. We've been doing this for 3 years now, and every time we get a little bit, so technically we have a special use permit or we got granted the special use permit, it's kind of confusing. I feel like we take a step back because there's always something that another ordinance that we try to find to, go back and to take away any progress being made. So, I very much understand they're against it. I understand they're trying to make arguments, against it, but I feel that we have presented, we got a unanimous 5-0 vote, in front of the planning commission because we did meet all of the criteria that was presented to us. So I just wanted to say that. I think I'm gonna not use time well. We have never rented out our place either. We've just been sitting in this 3-year process. So I also wanted to make that point, that we tried to follow every single rule. And so we have never rented our house out. I've always tried to be neighborly with my neighbors. I understand their strong opinions. I grew up in Millington. I'm trying to bring people to Millington. I'm not trying to do this to piss my neighbors off, but I get, obviously, this has been a heated debate a few years later, so that's what I have to say.
Thank you. Hello. Hold on 1 second, please.
You take your time.
All right, Cody, we're ready for you.
Hi, how you doing? The attorney had mentioned that he was referencing section 10-2, which if you are looking at our ordinances, that is in regards to commercial properties. That has nothing to do with a residential property, and lake residential is actually section 8. So therefore, that actually has no being towards anything that has to do with our property. Okay, and then further on, I do want to actually state that with our property, we've heard the argument that our property is actually zoned commercial or it is a business. It is not. If you go actually to the GIS page, which is attached on here, you will see that our property is zoned 401, which by state standards is residential. You'll also see a copy of our appraisal that states that the property was zoned residentially. Another thing, on, I believe it was 1218, yep, 1118, there was a section, an amendment made to 1902, which is appeals, that states that you have to file your motion within 30 days of the decision. So as far as our decision on our special use permit, which is attachment 4, it states on here that this applicant was granted, okay? And that granted date was October 14th, which is outside of 30 days. Doesn't matter when it's signed. The ordinance say granted. Okay, that is the 30 days, so we should not even be standing here in the first place. Otherwise, if you want to look further at the attachments, which if you want to take the extra time to go through them, that would be awesome. You put a lot of effort into them. You'll also notice that within these documents, it does say that on the special use permits, that, as far as the actual procedures document that was provided to us, it states that they expire after a year. But then on my actual special use permit, it says that the permit does not have an expiration date. I have a line right there. So I think clarity would be wonderful. Obviously not clear like charity. But yeah, so as far as that standard goes, I believe that the appeal was made under 1002 and 1803, which is the special use permit, as 1803 is. But 1002 is in regards to commercial properties, and we are not commercial. We are in the Lake Residential District, and we're outside of 30 days.
Thank you. Any questions?
No.
Okay, thank you. Others? Dan.
Hi. 7657
What's her name?
Osborne Drive,
Oh,
Millington.
what's your name? Sorry.
Diane.
Oh, sorry, I missed that.
I addressed you, but I overthought it. Thank you, sir.
What's your last name, Diane?
Wood.
I'm gonna restart your timer. Hold on. My bad. Okay, go ahead.
And I'm at 3149 Murphy Lake Road. Also, and Cody Clark just mentioned 4-2, and that is a different part of the ordinance. It's, or I mean 10-2.
10-2, yeah.
It's really 10-2, and they're two different ordinances. They're not the same one. We're talking about two different things. Not the same thing. So you guys should know that as you're looking thing up that he misspoke. And that's a dash and a dot. Okay. And I think that if you are put on the board, it is your job to read everything. You don't go into the bank and get a mortgage on your home and not read it. You can't sign papers that are legal papers without reading them. That's your job. And you can't say, well, look at how big this is. Well, sure, it's big, but everything's big. That's your job, is to do this. Impression of something isn't the law. And I sat and listened to a lot of hearsay up here. Well, I looked at the person on the board and the look on their face told me that they didn't know about it either. That's hearsay. That don't stand up in a court of law at all. I only have one question that I've got to ask of you as you're, I know it was brought up at a meeting before, but twice this month it has happened on Osborne Drive that the ambulances come down. They could get as far as my driveway and no further. So whoever runs for the rescue here in town that's got the big red truck, he ended up having to drive down to the people's house, load them in the back of their vehicle, then drive them down to Emery Close's driveway to drop them off. The roads are very narrow. They're private roads. And sometimes I only think when you're allowing these people to get permits, you got to remember that we've got, when they're parking on the sides of the road, we still got to be able to get the ambulances and the fire trucks. And matter of fact, I had the fire truck at my house 2 months ago because I'd left something on the stove. The same thing they said, the fire truck said I was surprised we could get around the curve. Thank you.
Thank you.
Thanks. Ordinances in front of you, I believe, but it's everything on the 10 and C commercial district. There's only a 10.01, 10.02, and 10.03. That's all there is. If you need a copy, they're here. So everything that was cited is all the commercial, or the discussion of the rentals is all for residential, as Cody pointed out.
Commercial, if you're.
And just keep in mind, there's other issues on and off the lake, vacation rentals and turning everybody out of parties and so forth, but that's not a discussion for the. So just want, I think you guys are going to this. I just thought I'd bring it to your attention. Thank you.
Okay, thank you.
Can I speak now?
Absolutely.
So the only thing I want to draw to your attention is that, again, we're interchanging things. So the 1002 that was referenced in your appeal references an ordinance amendment. And the 10.2 that is in the commercial district is in the ordinance itself. So there's two totally separate documents. I just wanted to make sure everybody understood that.
And Tammy, the 10-2 is a valid ordinance at this time, correct?
It's, I
Yes.
say so, it's an
Yes.
ordinance amendment.
All right, thank you.
Thank you. Others?
Ten dash O two, what they're referring to, guys, is it's it refers to 12.02 setback stuff. What they're talking about is it's 80 feet, lake residential. It's not commercial, lake residential. It's 80 feet for frontage. 12,000 square feet. There's got to be the lot size. They don't meet that. If you look at your stuff that they sent you, with the layout, it's 50 feet.
And you referenced 12.02 as the document for setbacks, correct?
Yep.
Okay.
12.02 would be the original ordinance. The 10.02 or whatever. it's
10-2.
Thank you. 10-2 is the ordinance amendment that changes to section 12.
10-2 is the township private road ordinance.
Right, which amends section 12.
Gotcha.
Does that make sense?
Yes.
Is that on the website, just for clarity?
I
Uncertain.
have any.
You'd have, yeah. You'd have. All right, next. All right. Did that close public comment? All right. Motion to close public comment. Do we need a motion? I don't think so. Closing public comment, and there have been no letters submitted. All right, on to discussion and action. From what I'm hearing, the issue of setbacks was brought up. They mentioned 12.02. I'll have to reference that. There's a grid somewhere in the ordinance, though. That might be where it's at. The private road ordinance, which we do have a copy of. I believe it was included with the appeal. That's a separate amended ordinance. 30, the 30-day appeal window, I think we need to address that. I think that's it. I think those are the items for discussion. Are there any others that we need to hash there?
30-day appeal. What was the date? It was October.
Well, we can hit that one.
Yep.
Okay, I'm just setting the framework first.
Yep.
Any other? Of course, they can come up and say, come up. All right, let's do it the 30-day appeal first. The statement is that the permit was issued on October 14th.
10/14.
However, if we go to the attorney-client privilege information, I actually asked this and it was addressed. So the very last page in your document or binder. Though they are accurate about a 30-day appeal window, that ordinance did not take effect until December 11th. And their appeal was made on December 4th. So prior to December 11th, you could make an appeal at any time. And that was, we deliberated on that and we sent our information forward. I believe it was this summer because I presented to the board and they created that ordinance.
On December 11th.
That's when it took effect. That's correct? Both concur. Okay. So I think that we are within the 30-day timeline based on our communications and just based on when that ordinance took effect. Road ordinance. Take a look at that.
So
provided as page 32 in our, Lord only knows what tab this is. It's two tabs back.
Yeah, so when I look at this, Robert, I mean, I'm looking at this and it says an ordinance to regulate the design, construction, inspection, approval, and maintenance of private roads within the township. The township of Millington ordains. I mean, the first section A, it says right here, the ordinance shall apply to all private roads constructed, altered, or extended within the township. I believe the intent of this document is for any new roads being put in or any new land developments. That is what this is all about. This is for somebody who's going to subdivide land and put in a subdivision. That's what this whole entire document is about. So to say that it applies to an existing private road for the purposes of lot requirements that doesn't make any sense. This is for newly developed roads, and that's why they have the lot frontage in there. I think the attorney cited C, no zoning compliance permit, building permit, or certificate of occupancy for any structure shall be issued within the township unless the parcel or lot fronts on an existing road. Each lot or parcel shall have road frontage equal to the minimum lot width required by the applicable provisions of the zoning ordinance. Private roads shall not be deeded or dedicated to the township. Private roads shall not be maintained by the township except pursuant to duly established special assessment districts, which requires property. I mean, this is what this looks like to me, and that's the intent of this document. It talks about easement width 66 feet. This is for when somebody goes to develop land. This is not, and I know this because I've tried to develop land myself, and this is what Terry Jones hit me with back in the day. I don't know if he's the one that signed it or Robert Ward signed it, but I mean, for them to use that as their argument, and when you said, she said, "Do I understand it?" I think I understand it too well. It's like drawing. That's a long shot trying to use this as the argument for that. In my opinion,
Okay. If you look at page 55 in this, they did have the plat plan for the Osborne subdivision where this land is located. And I can see at one end it is at least 66 feet. This also states that the road, let's see where this was platted in
1942.
So certainly before the ordinance was created.
Definitely.
Yep, okay.
Oh, we do.
Please. We're doing so well tonight.
I just don't see that as a valid argument for why to.
Do you have any statements on that, Mr. Moore?
No.
Okay. Setback. So it's mentioned that they do not have proper setbacks for this property. And at the very least, that the Planning Commission did not review setbacks, I believe is really what that statement was. Correct? Okay, so they did not review the setbacks. So we'll have to review the minutes regarding that, number one. But we can also go through with the packet that was submitted by Opperman Clark on page 47, their survey. Page 48 is the GIS, even though the red on there certainly seems wildly off from the survey, but I understand that those are not 100% accurate when they do their image there. We have the housing size, which is 740 square feet. That's page 49. That's what they submitted. Page 50 includes distances that they provided. It doesn't necessarily address setbacks in that. It shows from the side of the house to the property line, and nothing shows from the house to the road. There's no mention of the shed. Which if I go back to page 47, the survey, it looks like the shed's sitting on the property.
Yes.
Would,
There's a lot of those out there.
yeah.
That was just a question.
Cody, I'll ask you that question.
Oh, sorry, the township filed me a complaint about that shed, and then they, repealed it through the attorney. They said, take that out
But
because
it-
it was there for the last 35 years.
But it is sitting on the property line.
That's a lot.
Okay, well, thank you. Okay. Thank you. Page 30. What's 51 here? 51 refers to the Utley property. If I go back to our table of contents. Okay. So did the planning commission setbacks? What are the setbacks? That was section 12.
12.1.
Page number. All right, 12.02. For lake residential, 80 feet in width, which the property is not. Front yard setback, which that would be to the lake. Side yard setback is 3 and 10. The shed certainly doesn't comply with that. Cody, I'd like to ask you a question if you don't mind.
Yeah.
What is the setback from the house to the property line?
We did visit this information with Alden during our special use meeting. I know that we didn't talk about setbacks, but that was actually a very big discussion. Because we know we have a smaller lot. We've never shied away from that. Actually, many of the neighbors around us have small lots. It's a very, tight lake with a lot of lake cabins and cottages. I think you're gonna find that across the lake. But as far as if you're looking at, from the house to the road, I tried to go out there and measure because my wife's in real estate. I handle mortgages. We have the good old walking measure, right? So for the driveway itself, the approach, which is the top of the hill as to where we park, is 44 feet long, and then it's another 30-foot drop. So we are about 65 to 70 feet from the road.
That's the parking, not the house, though.
The house is right next to the Drury approach at the top. As far as my total measurement, I apologize. It's 45 feet is the total measurement of the approach.
But that's of the approach.
Yeah.
What about the house? What's the front end of that house to the center of that road?
That is a phenomenal question. I don't have that measurement for you on hand.
I don't think we ever measured that.
Yeah, that wasn't ever something that was
We tried
discussed.
to go exactly what was needed for the special use permit, and so we did exactly that, and so we don't probably have that measured.
And we were also explained as far as the setbacks rule, it's 3 and then a total of 10 feet, and it only applies to the house. They didn't say that applied to the insurance.
Okay, thank you, thank you. All right, appreciate it.
Yeah.
All right, what do the minutes say? Planning Commission meeting, special use hearing, page 56. maybe we. Special use hearing started on page 57, about a third down. All right, they went right through. So, commission members reviewed the site plan and scale drawing and parking and property description. All fulfilled 18.01 of the ordinance. It's 1801 of the state. 1801 states, for special land uses, written application shall be submitted to the planning commission. Such application shall contain a description of the proposed use, legal description and street location of the property of which the proposed use to be located, the signature of the property owner, signature of the petitioner. Different. A scale drawing of the site. A scale drawing shall show existing and proposed buildings, driveways, points of ingress and egress, parking areas, fencing, landscaping, signs, and road right-of-ways.
That's 1801.
Correct. According to them, the hearing has no proper notification. The hearing has had proper notification per 18.02. Standards of Article 18.03 were reviewed. Not all members agreed that it was in harmony with the surrounding property. 1803B, no traffic hazard is created due to adequate parking. 1803C, site layout noted close boundaries to property lines on one side and could be a nuisance. Discussion on fencing to help make close boundary less a problem. Okay. 1803D, all other specific requirements of zoning district will be met. Which 1803D states, all specific requirements of the zoning district where the proposed use would be located shall be complied with. (1804) Decision, motion by Maschke. Do I say that correct, Ed?
You said it correct.
Thank you. Okay. To approve the SLUP. Oh no, did I make an error?
No, you're reading it right.
No, the SOUP for the Dudleys. This one starts on page 58. We did two of them in the same night. Oh, great apologies. All right, start that over.
Just need to go further down, right? And that's not often required.
Yep, we'll get into their decision.
I didn't catch it until I read that.
Oh, yeah, until I saw Dudley. Darn it. Okay. Well, let's start that piece over.
Very similar.
All right, so now page 60 for the Cody Clark and Rachel Opperman. Article 1801 meets the requirements, which that was the application going back to the description of the property. Okay. 1802, the hearing followed proper procedures. They should have followed notice, and it hasn't been appealed. So, 1803A, the request meets the requirements of size, location, and character, being in harmony with surrounding neighborhood. 1803B meets the requirement as it does not create a traffic hazard. 1803C meets the requirements of site layout and has adequate boundaries and fence so as not to create a nuisance. 1803D will comply with specific requirements of the zoning district and follow the township STR ordinance. Motion was made. They limited the parking, 4 people at a time, quiet time. Conditions E through K. That's from the template that was mentioned during the last special use hearing, by the way, as it states right on here. Motion, who made the motion? Motion was made by Pletcher, seconded by Maschke, and it carried unanimously. All right, comments? 1st comment is they're doing better at documenting. (1803C) versus 12.02, the table. I guess that's where my question comes in. It points right back to the statement of setbacks by the petitioner.
And what is the exact measurement that it's off by?
Actually, they don't know.
So we don't even know.
Correct.
Okay. So we don't know what it is.
That also means that the planning commission didn't know when they made the decision, because they didn't ask. Nobody told them.
And it's not in the minute. Well, I guess it really shouldn't be in the minutes. Lewin takes really good minutes. Okay. Isn't it a very small dimension too? I mean, it's 7 feet on one side and 3 on the, or what is the total of 10, 7 on, and we don't know what the measurement is.
And it's not 66. I mean, the right of way is 66, which means you need to be 33 feet from the center of the road.
Well, I mean that I mean
Please,
that whole
please.
entire lake is.
We're having our discussion. Excuse me.
What is the specific setback if they are? In addition to 3 requires dimensional requirements more than 6 feet. Well, that's the 66 feet. That's the other one I just read. In addition to the frontage, this property does not meet the side lot dimensional requirement of the ordinance. Which is the very reason another applicant was denied.
What page was that on? I remember
This is
reading
page 30
Thank
at
you.
the very bottom. the second paragraph from the bottom, in addition to issues with frontage.
Thank you.
That I was reading when you were.
I remember reading that, yes. And they're stating that's the very reason that Michael Utley application was denied. We can go back and look at the minutes, but
Yeah, we might need to see why the.
and I believe we made sure we had those. Please, please.
You mind if I show you the table?
Pardon me?
Can I show you the table for the setback?
We have it.
It's 10 feet
We have it.
from front and backyard.
We have it right here. So thank you. When was Utley? Where's that table of contents? We read it.
Say that that was on 50s. In there.
Utley site plan was 51. Please. We're doing so well tonight. 56 and 61. Do we remember what night the Utley presented his?
I think it's in that book right there, if I can look.
Absolutely.
Yeah, that's
It's probably October 14th or November the 11th. If I have meeting minutes for all, I guess we can go back in there.
November 11th.
November 11th? We got it, man. Thank you. All right, so those are on page 61 of this section. Thank you, Matt. And Tammy. All right, so on page 62, public hearing open for Michael Utley request.
Yeah, at the very bottom there.
Yep, and I did observe that one. I sat in the audience.
That's out there also.
Mm-hmm. They mentioned parking and trespassing a problem on a shared driveway is a concern. Site layout was a concern because of the house being 1.7 feet off the property line. Close property lines on the other. So it does not meet requirements in the standards of section 1803A regarding location, size, and character being in harmony with the surrounding neighborhood. Shared driveway constitutes a nuisance. Jerusalem made a motion to deny because of site layout and size does not meet the standards of the Millington Township Ordinance, section 18.03, and intensity of use and nuisance, 18.03C. It was 18.03A for the other. Fletcher seconded, and Maschke voted no. Opperman, yes. Pletcher, yes. Gruzel, yes. Zavitz, yes. So it was denied. Because of 1803A and C based on their minutes.
You have 1803 open right now.
Right here.
Yeah, I see that. I don't have a copy right. Let me open it up. Let's see.
One doesn't meet the requirements and they deny it. The other doesn't meet the requirements and they accept it.
Oh, I mean 1.7, right? 1.7 feet off property.
Which was for the Utley property.
Right. So this says the location, size, and character of the proposed use shall be in harmony with the and appropriate to the surrounding neighborhood. I have to imagine that the surrounding neighborhood is probably identical sheds sitting on lot lines, houses 1, 2, 3, 5 feet off property lines. I don't know how that could be any more harmonious.
The lot widths are certainly, well, we have the plat plan.
I mean, this is the lake, right?
We have the subdivision plat plan.
So I'll go back to lots, setbacks, and I read through the appeal packet sent by the attorney for Lay and Close, and they keep citing the private road ordinance, which is where they're getting all this from. Once again, so these setbacks, as the zoning administrator surely knows, setbacks are for, it's guidelines for new construction. If the Clark Coppermans or whatever are getting a shed, right, they have to comply with the setbacks. If they are building a house, they have to comply with the setbacks. You just built a house, right? I mean, you have the process.
Yep. Absolutely.
These are all existing structures, right? Okay, so
They bought them that way.
if they bought them that way and they're existing structures, that is what setbacks are for. That is the intent. So once again, the 12.2, saying that that was a long shot. The setbacks it's all based off the private road ordinance, and I can't see using that as a reason to deny this. The Utley property, we're not even talking about that one. That one's obviously already done. But I would say that one probably, if you use the term harmony, if you have a lake house and your setbacks are probably less than what they should be, 1.7 feet. I used to live on a lake. I know how that is. You're using your neighbor's driveway. The houses are too close together. That's how it is. It couldn't be any more in harmony with what the environment is out there. So I don't see that as any reason to deny this. I think we need to affirm the decision of the planning commission. This seems like an easy decision.
Gentlemen, if it matters, I did find my survey, which has a scale, and we are within.
We'll take it.
Because the ordinance does say that it's from right of roadway, and the lot ends there, but it's the roadway. So as far as the scale, we're much over 10 feet.
Thank you. Thank you.
Oh, there we go.
It's there. So the only thing mentioned against 12.02 then would be the size of the house, essentially.
That is in his packet with the size of the house structure. I did look at that.
In which, yes, that is if you're going to build a new house, which of course they're not doing. So did the planning commission make a valid decision utilizing the required information? This survey, I guess there's the question, and I believe they actually did have that. Let me check here. Yep, page 47. All right. Any other questions or things to work through?
I don't have any other questions.
No.
I'm ready to make a motion.
So be it.
I will make a motion to affirm the planning commission's decision to approve the special land use permit for the Opera and Clark short-term rental,
Which denies the appeal.
which denies the appeal. Yes.
Second it.
Second? Okay. Roll call vote. Be pretty easy to work through with three.
Yeah.
Escape.
Yes.
Or Bernard, yes. Appeal has been denied. Okay, Mr. Opperman. Okay, closing the special meeting and returning to the regular meeting.
Make a motion to do that, or do you?
Do we need a motion?
No, I don't think we do.
Mr. Love, do we need a motion to close the special meeting and move to the regular meeting? No? Beautiful. Mr. Opperman, please come back.
No, you're fine. You're fine.
Okay. We are on to, thank you for your patience, sir. We are on to ZBA member comments. I do have a few. Number one, as we discussed during the last meeting, actually you brought it up there, Mr. Opperman, was to record training. All members, if my memory is correct, attended the MTA conference on May 22nd.
Drinking?
Yep.
Yeah.
And all of us were there.
Yes.
Mm-hmm.
So can you list
Yeah.
Hager, Moore, Close, Zansky, Opperman, Burns, Bernard? The training was 4.5 hours in length. Thus, at least to that meets everyone's training requirement through May. My next statement,
What's the date on that?
May 22nd, 2024.
May 22nd, 2020.
My next one is a very valid point was brought up tonight about process of notifying the property owner in the event of an appeal.
Right. That's a good point.
Cody, without much detail, were you notified at all?
Letter in the mail that said, if you have an appeal hearing, show up on this day. No note as to why, no reasoning, just show up.
Okay. I would like it just noted in the minutes that when we do our bylaw and procedure discussion, that we discuss that matter. Particularly the property owner at least receiving a copy of the appeal. Or notifying them at least how they can obtain it. And finally, I guess two more. Thank you to the ZBA members. This was not an easy meeting. And thank you to the audience. Truly, this was one of our better meetings as far as maintaining the peace, and it was greatly appreciated. All right, that's it for me. Other ZBA comments?
I would like to say that I think as a ZBA, as a township, I don't think any of us are perfect. And I think with everything being said and no one is going to be perfect in what they do, and especially some of us that are new. But I do appreciate all the work that Tammy does. And it makes it easy for a lot of us. You know, and like I said, I don't think no one's perfect, but you know, I think we're lucky to have Tammy.
Agreed. Thank you, and this was incredibly helpful.
I have nothing.
Nothing?
No.
Nothing? Okay.
Hey, Robert, Just a reminder of the weight trim training in March 10th.
Thank you.
I
No,
just want to remind you.
Yep,
I don't
we-
mean to butt in, but
nope, I appreciate that. Note that we should all have received an email, I believe, from Jackie about that training.
Yes.
And
March
strongly encourage everybody to attend, as I know that
Absolutely.
that's going to be probably another issue that will enter our world as the ZBA. It's
6 p.m.
our standard meeting time. Okay. All right, so 8:51. Motion to adjourn.
I'll second that.
All in favor?
Aye.
Aye.
Beautiful. Thank you all.
One shot.